way,
I don't
my
drink
way.
anyway.
Either one are pretty, I would go south.
What?
Well,
Except he never retired. He retired when he was 75.
Oh, okay.
And then Frank.
Yes, yes.
Why I left. He did,
They must have each other's cell phone number in the morning. Good observation. Good observation.
He actually was better in some, because his voice by that time was completely shot.
Yeah.
Cigarettes, booze, whatever. Old Frankie, 1,500 singles, nobody would ever come close.
wow,
Well, he started in the 30s and ended in the 80s.
true. Well, he had one of the best lines. It's like, I feel sorry for people who think that when they wake up in the morning, that's the best they're gonna feel all day.
Yeah, that's,
1 minute for chairman.
ready, get set. Who's got the clock? You do. Of course you do.
Good morning, everyone, and welcome to our meeting today. And just for those of you who are interested and might get hungry at some point in time, there's pizza, sandwiches, and subs, and salad. At what time?
11:30, 12.
11:30. So you don't have to make arguments long enough to stay that long.
I was gonna say, I'm hoping to
You're
be,
welcome to make short arguments and then come back and have lunch with us. But I wanted you to know that in the event that things go south, there'll be some sustenance.
Maybe
So,
we should bring the food in here.
you.
See how long the
Right, we can-
arguments last.
we can eat and we can continue with our arguments. Well, we're here today courtesy of Judge Rebecca L. Green Street. And I just would like to say, for the record, that the commission appreciates her efforts in working on this case. And I'd also like to say that, you know, when we have something like this, I go over and I look at the work that's been done. It's pretty incredible. So I looked at what Mark Lawrence had to deal with, and it's just a lot of exhibits, people, and then he has to contend with the lawyers. And vice versa, by the way, we understand it, you know. So I want to thank the parties for really a lot of work they've done in helping the commission, and also obviously staff for all the work it's done. So the conclusion that the judge said was that the commission's findings and reasoning must clearly appear to this court. She's saying we didn't do that, obviously. An administrative agency maintains an obligation to explain how its judgment is rendered. Without this explanation, this court cannot evaluate the order and logic behind the deductive process. Accordingly, Order 9953 is reversed and remanded back to the commission for further findings of fact and conclusions of law consistent with this opinion. Now, there's no instructions as to what process we should follow, and I've been on the commission for quite a while, and I don't believe this has ever occurred to us before. I think maybe once we had one or two issues relating to confidentiality that were returned to us, and we disposed of, but not without this sort of a get-together. So what I'd like to do is to call on Ms. Pope, because I abstained in the vote that we're talking about, and Commissioner Conaway was unavailable due to a conflict in schedule and did not hear the evidence. So I want to hear from the Attorney General's office as to what participation level Commissioner Conaway and I can have in this particular gathering.
Thank you, Chairman. You know, as you laid out, the court has provided that there was not sufficient evidence on the record and in the decision. And I think that right now the commissioners have two options in front of them, how I see them. First would be a limited approach, which the commissioners would decide and hear the same arguments presented as originally for a second time to refresh themselves before, they make a vote whichever way to supplement their decision. So it would be limited to what's already been presented and no new additional evidence would be presented. That would mean that Chairman Winslow, you could participate as chairman, direct the other commissioners as you usually do in a commission meeting, but you would also abstain. And Commissioner Conaway would not vote because she was absent the first time around. That would mean that Commissioner Gray, Commissioner Drexler, and Commissioner Correa could participate and vote. The second option, as I see it, is that each commissioner could participate. The Superior Court remanded and reversed the decision, so it could be seen with fresh eyes, and all commissioners could participate. Once again, no new evidence should be presented today, if that was the choice made by the commissioners. It should be limited to what's already been presented, what's already on the record, and I believe the commissioners would have to vote to go on all, or make a decision collectively, or the chairman to have all five participate. And if, in some instance that there is additional evidence which the parties would potentially want to incorporate into the record, then I think that a hearing would have to be scheduled. The matter on the agenda today is on the regular agenda, so I believe that whatever is heard today should be what has already been presented. So basically, I think that the commissioners have two options. One, to hear it as originally heard, with the three commissioners who voted being able to vote again and the chairman directing, or two, to have all five commissioners participate with the same evidence presented.
Thank you, Ms. Pope.
Chairman
Iori,
Winslow, I actually have a question, I
Yes,
think,
ma'am.
related to that. When you abstained back in August of 2021, was it that long ago? You didn't explain why you were abstaining, and you didn't abstain from any of the other votes that day. So it's unclear as to why you were abstaining. So I'm not sure that you would necessarily have to continue to take that position today, given that I'm not going to say what's before you now is a new presentation, because it's not. But what is, I guess, new in the sense is your deliberations.
Thank you, Ms. Iori. Who's going to speak for Delmarva Power and Light on this issue?
That would be me,
Okay.
Chairman Winslow. Courtney Schultz, thank you again for having me. I actually tend to agree with Ms. Iori. Your abstention was not for any reasons of conflict. It was, if you read the transcript, to make Ms. Iori feel better. So I think that, you could vote today if you chose the limited option.
Thank you very much. Commissioners, do you have any comments or preferences?
If I may, Mr. Chairman. I think, in my mind, I'm going to find it very difficult if we embark on either pathway to reconcile what is already in the record and what steps outside of the record in order for us to get sufficient information for informed decision-making. So maybe it's just me, but if the court is asking us for rationale on the basis of our decision and we need specific information which any of the lawyers perceive steps outside the bounds of what has been presented as evidentiary, then we're going to be in a lot of what I consider to be small battles about what's in, what's out, what can come into the record. So I'm a little confounded as to how we're going to organize and manage that process as we walk through.
Well, I would just tell you that there's not going to be any opening of the record. We're just going to consider what is already on the record unless there's some unusual request, and of course, Mr. Geddes has his.
If I could respond to Commissioner Gray's concern, I think all the court is asking is, please give us the reasons why you included it in rate base. Specifically, what part of the statute that deals with rate base do you believe that these expenses fall in? Hypothetically, I'm not suggesting anything. Do you believe that it creates a cash working capital requirement? Is it part of some miscellaneous asset classification? Or is it an essential element for the utility to provide service? That, I don't think, is outside the record, because what you're doing is you're saying, okay, we decided this is part of rate base, and we are now telling you why we think it is part of rate base. That is in the construct of what I think Ms. Pope referred to as a limited approach. Rather than hearing all of the substantial arguments again, and perhaps taking evidence in a future proceeding with regard to the issue, I think, my personal opinion, the court is just saying, give us something. You didn't give us enough, or her, us, court, whatever, to determine whether your decision was appropriate. And that's all that the court is asking. And I think if you marry up your conclusion with the statute and the reasons why, you haven't gone outside the record. You have supplemented to the extent that you've told a reviewing tribunal, if that's where it goes, why you believe these expenses should be part of rate base. Thank you.
Ms. Iori.
Thank you, Chairman Winslow and Commissioners. I would agree with Mr. Gaddis except for one thing, and that is,
Sorry,
I'm sorry?
I apologize.
And that is that there is one argument that, if made, does go outside the record because there was no evidence presented on it. I will refrain from addressing it specifically right now, and I will wait to hear whether Delmarva or perhaps staff, which, and I will note for the record, that staff did not take a position on this issue below during the hearings. So,
Staff is not going to argue the substance of this issue because we did not take a position, but process is process, and that's different. Thank you.
I agree that process is process, and I was unsure that where you were going with that, whether it was stepping over into substance. So that was my only concern. Be assured that if I hear what I have the concern about, I will address it. However, I would also note that Judge Greenstreet said that you had not explained why you rejected the hearing examiner's recommendation. And she indicated that you at least need to address why you rejected your subordinate's recommendation. So that would be something that in your deliberations you would need to address as well, I think, to comply with the court's directions.
Thank you, Chairman Winslow. I agree with Mr. Geddes and with Ms. Iori. I think that the issue before the commission today is very limited. It is based on Judge Greenstreet's opinion. She didn't find that your decision was wrong. That's not the issue. The issue is simply that it wasn't explained. And I think that the order below, where the commission summarized the evidence, provides the sufficient findings for you. It's just that they're in different sections, right? Delmarva argued this, which is based on precedent, and DPA argued this, which is supporting the hearing examiner, and we find, and it's one concluding paragraph. And so I think the issue here is just to be able to put out an order that essentially says, we voted before, and our finding was that the PPA was properly includable, and we don't have any reason to dispute that. The issue is, here's why it was reasonable to include the PPA as we had before. And in explaining why it's reasonable, you also then explain why the hearing examiner reached the wrong conclusion, which Delmarva articulated during the exceptions hearing, and which we can absolutely talk about again today, just to give you the roadmap as to how you can explain your decision adequately for the order.
I have one caveat to make to that. The commission needs to make findings, according to Judge Greenstreet's opinion, the commission needs to make factual findings on which it can then base conclusions of law, which to me goes a little further beyond just explaining why you are rejecting the hearing examiner. You would need to find facts, specific facts, that support your rejection of his factual findings. I'm not saying that you can't. I'm just saying that that is what you're going to need to do.
Are you saying that we cannot separate the legal and the factual determinations and first address the legal determinations, used and useful being one, and obviously a rate-based consideration being the other?
Well, oh, I'm sorry.
Without first tackling the factual background for the decision?
No, what I am saying is that you are going to need facts to support whatever legal conclusion you make. So, for example, if you make a legal conclusion that that it is used and useful, then you are going to have to make factual findings that support, one, that it is plant, because that's what the statute says, used and useful
Okay,
plant.
I understand where you're going, but don't go through the whole.
Okay, so but you understand where I'm going.
I do. I'm not sure that I agree with that, but I do understand what you're saying. And obviously, I would expect you to, as always, vigorously pursue that position if we go amiss, in your opinion. I would recommend to the commissioners that all five participate, and then as usual, if a commissioner does not feel that he or she should vote or wishes to abstain, obviously the commissioner has a right to do that, but I think that all of us should start off and do the usual, all five, considering the evidence or the comments and the evidence, and then move on from there. Do I have any comments from the commissioners, or anybody want to make a motion on that, or you want to make a motion with respect to a limited? Don't hesitate, just jump in if you want.
Mr. Chairman, for point of clarification, all five commissioners participate up to and their own consideration as to voting or abstaining. Does that imply the short route, as Ms. Pope pointed out, or the long route?
It implies the long route. It implies that every commissioner has a right to make that ultimate decision for himself or herself, so I could still abstain, and also Commissioner Conaway or Commissioner, anybody could exercise their right to vote. It's just we would have all five rather than just three.
That's correct, and I would just clarify that we would need a quorum to vote, so, only two people could potentially abstain if that is a selection.
So that's my motion. I'll make a motion to that effect.
I second the motion.
Is there any discussion on the motion? All those in favor signify by saying aye.
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 Did you vote?
Aye. Aye.
Okay, that motion carries. Okay, so I originally thought maybe we would just tackle the legal issues first, but maybe judging from what Ms. Iori said, perhaps we should do the factual issues first. And what I'm going to do is I'm going to make a couple of comments myself at some point in time, but I what I'd like to find out from the parties is what they perceive as their role in this. In other words, it seems to me that the judge has asked us to put on the table the factual and legal conclusions we've made. That doesn't necessarily imply the participation by the parties. But our commission policy has generally been that we like to hear from the parties, and even when perhaps we technically don't have to. So does the staff or DPA or Delmarva Power and Light have any objection or any comments about what the scope of the discussion today should be?
In accordance with what Ms. Iori stated, my comments were limited to process. On the substance, staff did not take a position in this case. It did not present a witness or a technical expert on the issue. In the prior case, it joined the DPA in its position of trying to exclude it, and in the other case, 05304, we didn't take a position either. So staff, on the substance with regard to what the appropriate facts and conclusions of law should be to support your initial decision, we will not be presenting any additional information to you. Thank you.
Okay, thank you. Ms. Iori?
Thank you, Chairman Winslow. The DPA is prepared to argue to the commission, but if the commission feels like it doesn't need oral argument, you're not going to hear anything different than you heard in August of 2021. Nothing has changed, and you're not reopening the record, so there are no factual changes. If the commission does not want to hear oral argument, we are fine with that too. It's your call, it's your meeting.
Thank you, Chairman Winslow. I think that Delmarva is pleased to proceed however Your Honor would like. If it is helpful to you, I am happy to answer any questions as you deliberate or assist with factual findings and conclusions with respect to the law in terms of argument. Again, as Ms. Iori stated, pertaining solely to what was already provided to you and heard previously during the exceptions argument.
But could I comment?
Yes, sir.
I hate to try to tell the commission how to proceed. I think all the comments are accurate, but one of the reasons we, in groups, I don't remember who, said that we thought a hearing would be appropriate is because it's almost been a year and a half since you heard the arguments the first time. And rather than looking at a cold record or briefs or information that's available to you, sometimes it's nice to have a live person articulate those positions for you so that it refreshes your recollection. Obviously, it's your choice as to you want to hear from the individuals, but I know, as we all know, Ms. Iori is prepared. And I believe Ms. Schultz is prepared as well to try to refresh your recollection on the substance. Thank you.
So the only one who's not going to make any arguments is asking the other parties to make the argument. Okay.
Funny how that happened, isn't it?
Commissioners, do you have any observations on this issue?
Mr. Chairman, I certainly agree with Mr. Geddes that if we're talking about factual and conclusions of law based on the record, which a year and a half ago, I would certainly benefit from some summary briefings that would articulate, I guess, the pros and cons of the parties around the table to the extent that they are relevant to our findings of facts and law.
Okay, so that's a reasonable comment, obviously. So why don't we have some, how much time do you think you need, Ms. Iori, with respect to the factual arguments? And a legal argument.
Okay, I was going to say, I didn't set my argument up to be here are the facts, here are the,
Yeah,
it was
no, I-
more of a combination. I suppose it depends on who's going first. But yes, the public advocate has just suggested 15 minutes apiece, and I think 15 minutes would certainly be more than sufficient for me to make an opening argument. My argument does address arguments that Delmarva has made. So I think the only rebuttal I would need is if there's an argument that they've made that I haven't anticipated.
Well, why don't we provide that there will be a rebuttal period if needed for 5 minutes? Would that be satisfactory?
That's
If it's not at the time, then just let me-
satisfactory to the DPA.
If it's not at the time and you feel that more time is needed, just let us know. Okay, so we're going to proceed with the DPA first, the company second. Staff will not be participating unless they speak up and ask questions or,
No, we don't anticipate participating in this part of the hearing.
okay, that's what I thought, but. Mrs. Iori, you have the floor in 15 minutes and 30 seconds.
Thank you. This is Mr. Watkins' schedule GAW4 from the electric case. Ignore that it says gas. He corrected that on the record. I'll be referring to this through my argument, so I thought it would be helpful for you to follow along.
You're going to have to share again.
I am.
Sorry. Don't worry.
Sorry.
We're good, we're good.
No, it's already in the record.
Mr. Zeminski knows his schedule backwards, so I don't think he really needs a copy, but, sorry.
Okay. A quick primer on what the so-called PPA is. And this so-called asset is the accumulated difference between the annual cash contributions that the company pays out to the pension trust fund and the annual GAAP accounting pension expenses. Because the annual pension expenses are based on numerous estimates of future and past obligations and investment portfolio performance, the expense may be negative. The negative GAAP-based expenses increase the so-called prepaid asset, even though not a single dollar of cash is involved. Now, the court specifically observed that in 2005, the commission did make factual findings on which it based its decision to include the PPA and the concomitant OPEB liabilities in rate base. At page 14 of the court's decision, the court noted the commission's findings in the 2005 case that Delmarva had a cash working capital requirement because of the negative pension expense, and that the decision, quote, the decision centered around rate reduction and creation of a CWC requirement, end quote. The court further noted that in docket 13-115, the commission proffered no explanation as to how the now positive pension expense affected its decision, provided no explanation as to how rate reduction factored into its decision, and didn't even mention cash working capital. That's at page 15 of the court's opinion. And as we've discussed, the reason that the court remanded the matter back to you is because you made no factual findings to support your decision to reject the hearing examiner's recommendation and include the PPA and OPEB liabilities in rate base. The facts on which you relied in 2005 to include the PPA and OPEB liability in rate base are no longer operative. Pension expense is no longer negative, it's positive. And positive pension expense increases rates, it does not decrease them. The DPA respectfully submits that there are no facts in this record that would support a decision to include the PPA and OPEB liabilities in rate base. Rate base is specifically defined in the Public Utilities Act in Section 102, subsection 3. And to be included in rate base, cash working capital must be investor supplied. That means supplied by investors, not ratepayers. Now, here are the facts that the DPA's witness presented in this case and that the hearing examiner found as facts. And I would note that the vast majority of this evidence if not all of it, was provided by Delmarva in response to DPA discovery on the issue. 1, Delmarva made no contributions to its pension plan from the time FAS 87 was adopted in 1987 until 1995. That's at paragraph 146 of the hearing examiner's recommendations. 2, as of December 31, 1996, the balance of Delmarva's prepaid pension asset was $33.288 million. That's at paragraphs 146 and 148 of the hearing examiner's recommendations. 3, between 1995 and 2008, Delmarva made no contributions to its pension plan. That's also paragraphs 146 and 148 of the hearing examiner's recommendations. 4, at the end of 2008, the so-called prepaid pension asset balance was $184.098 million. That's at paragraph 146 of the hearing examiner's recommendation. None of this balance was contributed by shareholders. It is solely a function of market gains. Now, fact number 5. Delmarva incurred a total of $177.389 million in pension expense between 2009 and 2019. $153.839 million of that was due to positive pension expense between 2009 and 2019, which ratepayers actually paid in rates, and $23.550 million in 2009 due to a transfer of employees from the Delmarva plan into other affiliated company plans. That's at paragraphs 146, 149 of the hearing examiner's report. Number 6, Delmarva contributed a total of $167.098 million to the pension fund between 2009 and 2019, and that's paragraph 146 of the hearing examiner's report. 7, despite Delmarva's contributions, the value of the plan assets fell by $10.291 million between 2009 and 2019. Paragraphs 146, 149, and all of that you can see from Schedule GAW 14. And finally, the pension plan assets, which far exceed the so-called prepaid pension asset, cannot be used for any purpose by Delmarva. It cannot use pension funds to make up a shortfall somewhere else. That money is untouchable, and that's paragraph 152 of the hearing examiner's report. Delmarva did not dispute any of those facts. Now, based on those facts, the hearing examiner found that none of the pension plan's balance could be considered cash working capital under Delaware law because none of it had been contributed by Delmarva investors. Again, to be cash working capital under Delaware law, it must be investor supplied under section 102(3)(f) of Title 26 of the Delaware Code. And remember, cash working capital was one of the reasons that you relied on in 2005 to include it in rate base. The hearing examiner also found that because Delmarva could not use the pension plan assets for any other purpose, it was not used in useful plant under Delaware law, and that's rate base section 102(3)(a). Now, we agree that the so-called asset isn't plant. We also agree that it's not used and useful in providing service to ratepayers. The PPA is essentially an accounting mirage. The net $37 million that Delmarva wants to include in rate base as a so-called PPA does not actually exist in dollars. It is the result of a GAAP financial reporting requirement. Now, Delmarva argues that, well, it did contribute money. It contributed $167 million to the pension plan between 2009 and 2019. It did, and we don't say otherwise. But what we're saying is that those contributions were insufficient to cover the expenses and asset adjustments that occurred during those years. That shows on Schedule GAW 14, and that was also Mr. Watkins' testimony, page 42. The entire balance of the so-called prepaid pension asset came from gains on the pension assets, not from Delmarva's contributions. Because even with Delmarva's contributions, the value of the asset declined, and that fact is uncontroverted. Delmarva also argues that ratepayers benefited from lower rates because the pension asset was included in rate base. Agreed, they didn't have to pay as much, but they still paid because Delmarva's rates during those years included the amount of the actuarially determined pension costs for the test period. Moreover, Delmarva's earned a return on the asset for all those years too, so Delmarva shareholders benefited. It was not a one-way street where ratepayers received all the benefits, as Delmarva tries to sell you. In other words, Delmarva's profits were increased by allowing a fictitious asset in rate base simply due to GAAP-based negative expenses. Delmarva also argues that ratepayers are still benefiting from Delmarva's pension expense because pension expense is $230 million lower than it would have been without the return on plan assets. That is irrelevant. Pension plan trustees have a fiduciary duty to invest pension funds in a prudent manner, and Delmarva has not argued otherwise. Delmarva also argues that the source of the funds is not dispositive, but it is dispositive if it's to be included in rate base. Section 102.3 specifically identifies what is and what is not an element of rate base, and the PPA must satisfy one of those elements to be properly included in rate base. Delmarva has not pointed to any element of rate base other than cash working capital that the so-called prepaid pension asset falls under. And if it's cash working capital, it's got to be investor supplied. Delmarva now argues that the fact that the pension expense is positive or negative is irrelevant. We would agree in the abstract, but that ship sailed in docket 05-304 when Delmarva argued that the fact that pension expense was negative was a reason that it should be included in rate base. And the commission specifically identified that fact as an important fact in its decision in that case. Now Delmarva argues that the PPA creates a cash working capital requirement. Now Delmarva made this argument in the 2005 rate case and when pension expense was negative and you accepted it. But the pension expense isn't negative anymore, so that rationale doesn't hold. What you have to look at is what have shareholders contributed. And GAW 14 shows mathematically that market gains far exceeded what Delmarva contributed, and that the entire PPA balance is due to market gains over the years. And that's what the hearing examiner found based on Delmarva's own records and evidence that we got in response to data requests. So that should be the end of the story. The hearing examiner saw the witnesses and assessed their credibility. He obviously found the DPA's witness to be more credible. Moreover, even if the PPA created a cash working capital requirement, which it does not and never did, it is not in the amount of the so-called PPA. It is not a dollar-for-dollar exchange. Delmarva didn't calculate what the so-called CWC requirement associated with the PPA is in this case, so there's nothing in the record to support what that requirement is, and Delmarva bears the burden of proof, not the DPA. Delmarva also contends that the PPA complies with GAAP. We are not arguing that it doesn't, but the Commission is not bound by GAAP for rate-making purposes, and in fact, the Commission has refused to follow GAAP for rate-making purposes before. For example, in docket number 9120, when Delmarva wanted ratepayers to pay for both a retired and a new cooling tower for its Indian River generation plant. Other commissions have excluded PPAs from rate base despite their complying with GAAP as well. So, including what is essentially a non-existent asset in rate base in this case, is a windfall for Delmarva shareholders. Delmarva has reaped that windfall since 2006, when the commission approved the order in docket 05-304, when it first placed the PPA in rate base. If you accept the hearing examiner's recommendation and his factual findings, you will have done what you are required to do under the requirements of the Administrative Procedures Act and as directed by Judge Greenstreet. You will have made the findings of fact supported by substantial evidence in the record, and you will have made a legal conclusion based on those factual findings that will withstand appeal. Thank you.
Thank you very much, Ms. Iori.
Thank you, Chairman Winslow, Commissioners. So, as you've just heard, Ms. Iori gave you a number of facts. I think the issue is, and I think as you rightly determined when you heard the arguments the first time around on exceptions, the hearing examiner looked at those facts, he just applied them wrong. And he twisted them to a narrative that supported what he wanted to do, which was not what led us to the conclusion that the PPA should be included, which is where this commission landed. So let me take them one at a time to summarize my prior argument for you. So as you've heard today, and as you're well aware at this point, the PPA has been included in rate base since docket 05304. And yes, in that docket, the PPA was negative, but in docket 13115, the PPA was positive. So the PPA has been included when it creates a higher expense for customers and also when it creates a lower expense for customers. So as previously argued, and as I think this commission would agree, the sole determining factor is not whether or not the PPA causes an increase or a decrease in the rate by its inclusion in rate base. And so there's essentially 4 areas concerning the findings that the hearing examiner had in his decision. And the first of those is he based his conclusion that the PPA should not be included upon determining that Delmarva's investors did not contribute to the plan. And simply put, as I explained before, it's just not true. What the balances are today and whether there's more or less and whether the returns and the investor-supplied capital have caused the balances to be higher or lower or require additional returns isn't the question. The question is, does it include investor-supplied capital? The answer is yes, it does. It includes $167 million of investor-supplied capital. And the argument that we have to look at what the fund balance is to determine whether or not capital that has been investor-supplied is there, it misses the forest through the trees in the sense that you have to look at the PPA as a cumulative event over time. You can't just take a snapshot of what exists today. You have to keep in mind that this has been created as a creature of the accounting standards since, I think, 1995, if we look at the chart. So it really is something that has to be considered holistically. And so, as we've said, you can see that we did contribute $167 million between 2009 and 2019. And the other point that we raised, and as you noted, that also was not a determining factor. In prior rate cases, there had been no investor contributions, and yet this commission still found that the PPA created the cash working capital requirement, and that was sufficient to include it in rate base. And that was true in 2005 when not a single penny had been contributed by investors. And if you look at the schedule that Ms. Iori just provided to you, you can see that on the top part of the schedule from the 1995 to 2008. That entire period was in the 05 rate case when PPA was included, in part, as Ms. Iori mentions, because it was negative, but also because the cash couldn't be touched for other purposes, and so the company had to fund its other obligations. And so when you move forward, you see the additional funds. The other thing I think is really important to keep in mind, and as I explained before, is that we're talking about investment returns versus investor contributions. And the real point is that if the returns of investments on the plan assets are so large, then investors need to contribute more money to create that lower pension expense for customers, right? It can't use the money, but it has to give them the benefit of the lower pension expense. And therein is where the cash working capital comes up. And so if returns conversely are not high enough to cover those costs, then investors are kicking in more money to fund the pension plan, and that also creates the cash working capital requirement. So either way you slice it, either way the company funds the plan or it funds the expense because of the plan. And so that is where the cash working capital comes in, and that is where it's abundantly clear, and your findings can easily conclude that Delmarva's investors have contributed to the plan, and they have contributed to the resulting operational expenses that result from the plan. So the second thing that the hearing examiner found is that the pension expense was positive, and that increases customer rates. Well, that's true, but as I noted before, that doesn't dictate recovery. The pension expense has been permitted when positive, when negative. It's not the deciding factor here. I think the other piece to keep in mind here as you're talking about, well, is it positive, is it negative, do customers' rates go up or go down, is that customers have benefited from allowing the PPA and the OPEB liability balances in rate base. If, again, we're taking a cumulative view here, if you look at from the beginning of time through docket 20149, the pension expense was $230 million less than it otherwise would have been if the commission did not include recognition of the investment returns in the PPA balance over the last 20 years. And that's important because, as you're aware, the impact as well, if you had not chosen to include the PPA in rate base, is that the pension expense in this electric rate case would have been higher, to the tune of nearly $13 million. And the OPEB expense would have been higher, to a tune of about $1.9 million. So there are corresponding impacts, and this commission decided that the appropriate course of action was to include the PPA, and that is where we should continue to find ourselves today, but these are the reasons why. They are supported by the record. You have already found them. The hearing examiner, quite frankly, got confused, is what I would argue, and that's abundantly clear when we look at the next point. In his reasoning for arguing that the PPA should not be included in rate base, he said that it was not used and useful. Well, quite frankly, the PPA doesn't have to be used and useful because it's not plant. The only thing that has to be used and useful, if we're using that category of the rate-based definition, is plant. And so, as I explained before, on this point, I think the hearing examiner simply misapplied the law. That argument was made before this commission previously in a prior rate case concerning the PPA, and this commission did not adopt that argument for DPA. And there's really no reason and no change in circumstances that would warrant it being adopted here and now. We talked a little bit about how the PPA balance isn't investor supplied and is not cash working capital. That was the conclusion of the hearing examiner. And I've worked my way through kind of explaining to you how the cash working capital requirement is created and how that happens based upon no matter who funds the asset or the liability, the shareholders or the customers. Either way you slice it, the funding is a cash working capital. It has to be paid back over time. We all agree, this commission found in 05-304 that the company cannot touch the plan assets, the money that it puts in that plan, whether it comes from investment returns or investor contributed capital. And those returns that do get generated, though, they have to be paid back. And that's where the investment by investors continually comes into play. And so essentially what you have is if you create a situation whereby the PPA is removed, then it creates cost-free working capital for customers. And that's not the right solution either. So in summary, I would point you back to your prior reasoning in docket 05-304, where you found that Delmarva couldn't access the asset to use it for other operating expenses. You determined it created a cash working capital requirement. I refer you back to docket 13115, where admittedly you found a less than detailed record than you'd like, but nevertheless, you still found that the balances should be included, even though It was not determined that investors had funded all of the balance, and it was positive. And so, in short, I think that you can't ignore then, and you can't ignore now, that you have a $230 million expense reduction that customers have realized through inclusion of the PPA. And in considering whether you remove it or you leave it in, the only way you achieve symmetry in rate making is to leave it in. And if you have any further questions as you deliberate on the findings and fact and conclusion of law, I would be happy to answer them. Thank you for your time.
Thank you. Ms. Ivory?
Thank you, Chairman Winslow. Short rebuttal. First of all, let's just dispose of your docket 13-115 right now. I would point you to Judge Greenstreet's observation in her opinion that in that docket, you proffered no explanation as to how the now positive pension expense affected your decision, provided no explanation as to how rate reduction figured into your decision, and didn't even mention cash working capital. She basically went to 13-115. So we are back to 05304. And with respect to that, Delmarva says you have to look at it cumulatively, having a difficult time with that word, over time. That's exactly what GAW 14 does. It's not a snapshot in time. It is looking at it over time. And over time, what that shows you is that the balance was not investor supplied. Delmarva argues that in 05-304, you didn't make it a part of your opinion that investor supplied was a big deal. Well, may I suggest to you that it's because you ignored that requirement. The argument was made, the hearing examiner ignored it, and the commission ignored it as well. I submit to you that was an error of law, because if it is cash working capital, it must be investor supplied. So, moving on. Delmarva says that you can't ignore the $230 million that ratepayers have been saved over the last 20 years, and you can't ignore it now. I would also suggest to you that you can't ignore the returns that shareholders have earned on that money over the last 20 years, and you can't ignore it now. So if you want to talk about fairness and symmetry in rate making, that fairness and symmetry goes both ways. So, the commission, finally, the hearing examiner was not confused on the cash working capital. He got it right. And Delmarva has just sat there and told you that it doesn't disagree with any of the facts that were laid out. It just disagrees with the interpretation of them. That does not mean his interpretation was wrong. In fact, his legal interpretation is right. If you are going to treat this as cash working capital, it has to be investor supplied, and the balance of that PPA is conclusively proven not to be investor supplied. Thank you.
Ms. Iori, with respect to the $167.098 contribution made that you referred to, and I believe was referred to by the company.
Well, I referred to it too. We don't dispute it.
Yeah, that's what I said. You referred to it. Does your argument ignore that contribution by the investors?
I'm sorry?
Does your argument ignore that contribution by the investors?
No, it doesn't. As I argued earlier, they did put in $167 million, but their expenses were $177 million during that same time period. So there is still, the balance still decreased by $10 million. So their contribution basically didn't do anything to alter the argument that the balance of what's in that PPA has all been the result of market gains.
Commissioners, any questions of the parties?
Mr. Chairman, I do have a few questions, if you don't mind, please.
Go ahead, sir.
So, coming into today's hearings, there were a couple of things I didn't understand, and I read through the record of the hearing that we held here. And first question I have would be for Ms. Iori. In the record, there was an agreement to the form of order that we actually voted on that day, and then the case came before the Superior Court. I don't quite understand whether or not I'm seeing a conflict or confusion between the statement in the record and the action with the court. Is there some way you can characterize or summarize what I missed in the two steps there? The agreement to the form of order and then the Superior Court appeal.
The form of, you're talking about the form of order that we actually appealed as opposed to the form of order, the minute order that the commission entered in August?
Well, I'm looking at the record that day where we took the vote on this matter.
So in
this
August.
Specific issue, not the full-blown everything, but I'm looking at this issue.
That was the same day.
Okay, so that is for me a little confusing, confounding, and I'm seeking some perspective from your side that would help me better understand the two steps, the two statements.
Okay, first of all, the minute order is not a final order. It specifically says that the commission's reasoning will be set forth in a later order at a later date. The minute order was agreed to so that Delmarva could put in the rates that fell out of the decisions that you made on August 4th. I think they wanted to get them in for a September 1st effective date. And so that's why the minute order went in that day, and that's why you signed that order. We agreed to that form of order, but it has never been, it was never been understood to be a final order, nor could it be, because there was no discussion of why the commission ruled as it did. That order did not come until January of 2022.
Okay, thank you. That helps me a lot. So, as I listen to the arguments in terms of the context of the previous order, on which I think in large measure I looked at as a precedent that gave us privilege to say the decision we make in this particular matter, we could use the previous order as a precedent to move forward. But I think you've explained to me in terms of the positive or the negative position of the PPA, as well as the cash working capital, are the key differences between these two matters. Is that what I'm understanding?
That was our argument, yes, that the facts that you relied on in 2005 to include it in rate base were different, and on a legal basis that you ignored the requirement that the cash working capital requirement be investor supplied.
Okay, I think I have a question for our legal counsel, but I'll hold it for right now because I'm not sure whether I want it public forum or I want it by executive advice.
I have a question for Ms. Schultz. Looking at the prepaid pension history, and if I'm just doing the addition and subtraction correctly, without the $167 million that was provided over the term from 2009 to 2019 by Delmarva, theoretically, the ending balance and the pension asset would be a negative because you wouldn't have any investment returns on the $167 million, nor would you have the $167 million that was supplied by Delmarva. Is that correct?
That's correct, Commissioner Dressler, because you can't ignore the benefit or the impact that the contributions of that $167 million had to the prepaid pension asset.
So it's all part of going in. It's fungible. So yeah, correct. It's part of that. Thank you.
May I address that briefly? If it's a liability, then it's going to be a deduction to rate base. So if they're going to want to include it in rate base, then you have to take the good with the bad. So if they had never put any money in, and that was the result that you got, they would have needed to reduce their rate base by whatever the amount of that deduction was. Or whatever the amount of that liability was, I'm sorry.
if I may, Commissioner Drexler, the opposite side according to that is the OPEB liability.
I'm sorry.
The OPEB
Which we
liability
don't-
is the equal and opposite side to the PPA.
Tell me what the acronym is.
Oh,
Other post-employment benefits.
Thank you.
And there is no evidence in the record of what that amount would have been, nor is,
Any further questions? I guess that does it. Gloria, do you want to take a break?
Mr. Chairman, I'd like to move for a short executive session to ask a few questions of our legal counsel.
Ordinarily, we ask them in open forum.
That's fine. So, Ms. Pope, do we, as commission today, just answer the court directly with our reasons, or is there an option to reverse our decision and adopt the hearing examiner's recommendation?
Well, you were, when the Superior Court issued their opinion, they reversed and remanded, so you would hear this with fresh eyes, so to speak. So you can vote, either way that you choose. It doesn't have to be the same vote as originally casted. It just has to have sufficient evidence and reasoning why you are voting the way you are.
Thank you.
Now, I have another question of the commissioners, and that is, having heard from Ms. Iori and having heard from the company, Ms. Schultz, with respect to the record, I need to know whether or not any commissioner or more than one commissioner would like us. I don't know that we have to make a decision today, is what I'm trying to say. It may be that we want to reflect upon what we've heard and go to our documents and do some additional work and come back in another day and state for the record the findings of fact and conclusions of law, or we can do it today. So I just want to find out from the commission what its preference might be. Okay, so we'll proceed as normal then, since there's been no comment otherwise. I do have some questions of the parties. Ms. Pope, with respect to the legal issue of used and useful, do you have any comments for the commissioners in terms of what that means and what the statutes are that are part of that definition?
Well, used and useful is in statute, it's in Title 26, Section 102, subsection 3A. And if the commissioners would like to review that statute, we could certainly print that off so everyone could have a copy. Maybe that would be more useful for everyone to consider if it's right in front of them, or I'm able to read it out loud too.
Why don't you read subsection A out loud for the commission's benefit?
Rate base means the original cost of all used and useful utility plant and intangible assets, either to the first person who committed said plant or assets to public use, or, at the option of the commission, the first recorded book cost of said plant or assets. Or then there's a colon, it says less. So that's part of the rate base calculation, so to speak.
And how about, is there any other provision that arguably gives the power to the commission to rule that the PPA is used and useful? I would point you to G.
Okay, subsection G says, any other element of property which, in the judgment of the commission, is necessary to the effective operation of the utility.
Mr. Chairman, may I insert just ask a quick question?
Certainly.
Ms. Pope, you mentioned in the first reading intangible asset. I'd ask both parties, does the PPA have the characteristic of an intangible asset?
Speaking on behalf of the DPA, I don't know that there's an answer to that. I actually looked that up, and I could not come to a decision on that. I would like to, after Ms. Schultz answers the question, I would like to address the reference to Section 3G, if I may.
Ms. Schultz?
Sure. The PPA would not be an intangible asset, Commissioner Ray. Intangible assets tend to be more things like software and similar items to those. IT, IP related.
Thank you.
Thank you. With respect to Section 3G, that argument was not made below. There was no evidence presented on it, and I think if the commission were to make a decision based on it, you might wind up in the same position another year and a half from now.
Respectfully, Commissioners, I disagree. This commission is entitled to look at the rate base statute and make a decision on whatever basis it deems appropriate. A finding it could make is that the hearing examiner got it wrong when he decided that the PPA had to be used and useful under Section A. They could decide he got it wrong when he didn't find that it was appropriately cash working capital under Section F. And they could also find that he got it wrong because you have the authority and the ability to classify any other element of property in your judgment, which is necessary to the effective operation of the utility, which is G.
And what I am arguing is that nobody made that argument below.
And
Well,
my
we've
response-
been directed by the court to provide on the record our conclusions with respect to the law, and whether or not they were argued previously. I think we are not limited to what was on the record before. I think we're limited only to what the law is. And I think that we have the right to do that, and that's a decision, obviously, that could be appealed. Ms. Summer, how about general jurisdiction and powers of the commission? What general jurisdiction and powers do we have as a commission?
Well, the commission has exclusive and original supervision and regulation of all public utilities over their rates, property rights, equipment, facilities, service territories, and franchises, so long as may be necessary for the purpose of carrying out the provisions of Title 26. And that is Section 201A, which is, the general jurisdiction and powers subsection of Title 26.
Commissioners, no questions on that? Okay, I think that at this time, if there are no other issues to discuss, we might as well start making some decisions and putting them down on paper. And let me go first, since I wasn't sure I could, but I will now that everyone has spoken. As the court has indicated, and as everyone in this room knows, our duty is to balance the interests of the utility and its ratepayers. This utility has 325,000 customers. I'm not sure how many employees it has, but it's got a a number of employees, and those employees are extremely important because they operate the utility in the snow, the cold, the rain. Simply put, they do a great job. They've done a great job for us, as the data indicates. We recognize those utility employees, and we recognize them as being important. We recognize that there are pay and benefits involved, which are very, very important and crucial to the utility, because the utility has to be full, has to have enough people to operate this system that brings electricity to all the customers. And I think that the commission has positively, given credit to the company where payments have been made with respect to personnel. The success of the company the success in getting employees and retaining employees is really critical to the utility to make sure it operates efficiently, and we have to do it obviously at a just and reasonable rate. It seems to me that the argument that the benefits under PPA are not used and useful I don't believe is accurate. I believe that although technically speaking, those employees aren't used and useful pursuant to plant, et cetera. I think that the legal basis for doing that has been stated on the record by Ms. Pope, which is 201A, is the general jurisdiction and powers. It gives us supervision and regulation of all public utilities, and also over their rates, property rights, et cetera. I would respectfully submit it's clear that we can make this decision based upon that statute alone, but we also have 102A, and we have 102G, which arguably, I believe, buttress the foundation of what we've got in terms of power to make decisions with respect to the supervision of utilities. So I would respectfully submit that that's the legal basis for our decision, and that we have the right to, that the used and useful term is not necessarily as applicable, so to speak, as you would consider the operation of a plant, for example. Also, we hesitate every time we have something that's variable, and the stock market is variable. It goes up and down, and we can't control it, and we can't time it, and we can't do anything but put our faith that eventually that it's going to grow and provide as we expect for our employees and their benefit plans. And to make a decision that one thing should be in or out based upon whether it's positive or negative seems to me not the right policy choice. Seems to me if it's appropriate to have PPA for the positive, it's appropriate for the negative and vice versa. I don't think it could be one decision on one way and the other decision the other. The company was out of pocket, as I understand it, $160 million for the arguments on both sides. And to use mathematics about the variability of the marketplace to undercut or to diminish that contribution is, I don't believe, a fair result. I believe that the testimony of Mr. Zeminski, as found in exhibit number 112, outweighs the evidence given by Mr. Glenn Watkins in exhibit number 98, and perhaps testimony elsewhere, in that Mr. Zeminski refers to the fact that there isn't precedence in this case, which should be given some credit, not totally ignored. And there's commission precedence in Maryland, is consistent with commission precedence in Delaware, and there's commission precedence elsewhere, according to the parties in the briefs I read, with respect to including PPA in the rate base. So, although I did abstain last time, and I wish I could tell you exactly why I did, but to be frank with you, I'm not positive. It's been a while. I must have been concerned about something, obviously. But these, I mean, the briefs written by the parties and the review of the record, to me, indicates that the PPA, there's no reason why the PPA could not be, and I think it's a good public policy for it to be in, whether it's a negative or a positive with respect to the growth of the fund. So this is my observations. And I've probably forgotten something, but if so, I'll chime in later. Commissioner Gray.
Thank you, Chair Winslow. So I'll start by saying that in large measure, in reading the record from the decision on this matter, my grounding was, for the most part, with precedent. And so also recognizing the parties at the table in terms of agreement with the form of order may have missignaled my direction in terms of decision-making also. I agree with the chair. I think the PPA is used and useful. So therefore, according to the decisions of the commission, should be qualified for rate base, positive or negative. I'd also recommend or suggest, recognize that ratepayers, they suffer ups and downs when fuel costs fluctuate. So the PPA fluctuations can also be expected as a consequence of things that are happening in the market space. And I do note from the record here that the company has contributed $167 million. The outcome of the PPA fluctuating up or down, the contributions from the company have been made. So I would support the decision that we made initially on this matter. Mr. Chair, I yield.
I would like to start by saying that I appreciate everybody's input. It is difficult to be in a position to determine what is fact and what is not fact. However, I will say that my original decision was based on primarily 18 years of precedent, including the 05 decision and the 13 decision, although I will say that Ms. Iori, your explanation that the 13 decision should be thrown out due to the fact that there was no support for the decision at that time is appropriate. Then we would then go back to the 05 decision, and that is 18 years of precedent for that decision. And I would agree with Harold that my decision was primarily based on that fact. Having reviewed in much more depth this information and hearing it in public twice now, I would agree with Dallas that this is a CWC under the definition of investor supplied. I would say in that case that $167 million was contributed by the company and should be by definition included in rate base. Additionally, and I may differ from my colleagues in saying that I believe PPA is an intangible asset. By definition, prepaid expenses are an intangible asset for future use. And so I think that further shores up my decision that it's important to include this in rate base. And finally, we've heard that both negative and positive pension expense impacts customers negatively and positively. Nonetheless, I think that if we are going to include the PPA in a negative environment, then we should also include it in a positive environment, because we don't know that next year isn't going to be a reversal from this year or last year or next year. So I don't think we can rely on investment returns to determine our decision, and that's where this inequity, this delta is coming from. So I don't think I'm going to reverse my decision at this time. Thank you.
Commissioner Conaway.
Having not been involved in the original discussion and decision, I will remain mute.
Commissioner Correa?
I agree with both of my colleagues because the vagaries of stock market and now the interest rates are not to be the part of any consideration, even on a personal basis and on for a company basis. So whether it's positive, whether it's negative, or whether it is same, if we consider that to be the part of or not to be the part of the rate base, I think we are depending on something constantly, continuously fluctuating. So, and that would have been my consideration at that time and now also. So I agree with both of my colleagues and consider my decision continued.
Okay. We'll just add for the record that I believe, from my reading of everything, that I accept the company and Ms. Schultz's argument with respect to cash working capital, so it's clear on the record that that's where I stand. And as part of any motion that's made, I would appreciate that we have, well, I guess we've talked on the record, so everyone's pretty clear about what we're doing. Any further comments? Commissioner Gray?
Mr. Chair, do you want to take a motion?
Yes, sir. No, 1 second. Ms. Pope?
Sorry.
I'm just trying to think about this out loud, but I think that the commissioners will be voting to amend Order 9953 to supply their insight. Or,
I believe that would be the most logical and efficient way to do it.
okay.
Wouldn't it be an amended order? And just for that issue, Jim?
Somebody's asking my opinion. I think, given, since the commissioner only acts by written order, that you could decide to direct your counsel to issue an opinion consistent with the comments as amendment to the original one, or if you choose, again, I'm of the school that you control your own agenda and how it's done. If you want to take a vote directing council to do that, that would be fine as well. But I do believe, at least from my perspective, process only, that there is enough information here that you could direct council to pen an order consistent with your stated conclusions and facts.
Commissioner Gray?
Mr. Gaddis, are you suggesting an order or an opinion? Either?
Well, technically, maybe it is, we usually do a final facts and opinions, so I think it would be an opinion
Okay.
consistent with the, I'm sorry, I didn't mean to interrupt, but consistent with the Superior Court directive.
Okay. So,
Ms. Schultz?
comment?
I was just going to say, I think that you could do it either way, and I think that you would simply want to have this record reflect the decision in terms of the vote to essentially mark what each commissioner has stated with respect to the inclusion, given the reversal, right? So I think that needs to be included.
So, Mr. Chairman, I'm gonna propose that we move forward in two ways. One, you have expressed an opinion, and I assume are prepared to take a vote, which would be different because the first vote was only with 3 commissioners. So my first motion would be that we vote as a commission to adopt the decision made originally on this matter. And I don't know the order number, sorry. 9953, if that's correct.
Yes.
So that we can get on the record the commissioners that agree with that original decision. That's my motion.
I don't think that's necessary. I mean, we've already agreed and signed an order, so there's nothing to the contrary, but for the fact that the court's asking us for the factual background for that decision and also the legal basis for the decision. So there's no need to say that we got it right the first time, because we're saying we got it right the first time. We're just telling you why.
I understand, Mr. Chairman, but You have rendered on the record comments and abstained from the first vote. So I'm only trying to capture your position unless you're intent on abstaining again.
I just think it's unnecessary.
Okay. So I'll move alternatively that we ask our counsel to assemble an opinion that captures the commentary on the record today in response to the Superior Court remand.
I second the motion.
Is there any discussion on the motion? The only discussion I have is that I like the motion, but I don't think that after more reflection, if they decide it should be an order rather than an opinion, I don't think that the heading is necessarily terribly significant. It's what's contained therein. So,
We could do excuse me, I have to ask permission, I apologize.
go ahead, Mr. Getz.
Point of
Please.
clarification, I'm allowed to ask for a point of clarification.
sir.
No, you could certainly style it as an opinion and an order.
I've already made it.
Nikki?
Okay, well, we're discussing it now. Okay, so we'll leave it as he made the motion. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Aye.
Okay, and Commissioner Conaway has very uncharacteristically remained silent, but she's not voting in this matter, so the motion carries. Guys are timing it perfectly for lunch. Once again, thank you all so much for your efforts. It's been really, Ms. Pope?
I just want to make sure that you voted chairman, right?
I
Okay.
did, yes, I
Yes.
voted aye.
Thank you.
Anything further?